Yeah. We could just get started and.
Okay, good morning, everybody. I think I'm going to filibuster for like 30 seconds in the hopes that Professor Riley, who I gather is in the building trying to find the room somewhere, is successful in doing so. But in any event, in a minute, I will turn things over to Corey Liu, who will to get us started with the panel. So, yeah, I think let's just go ahead and do that. Okay, over to you, Corey.
Thank you. Well, as the son of immigrants from China, who grew up under communism, certainly America's concern for discrimination and inclusion of people of all different races and background was something that was very near and dear to me personally. As a kid growing up on the playground, I was used to being made fun of for the way I looked or food I ate or things like that. And so much of our country's commitment to anti-discrimination and inclusion was very important to me. And yet at the same time, a lot of Asian Americans, as they started to get to the college application process and were hearing some of the descriptions of what was going on in the consideration of race in admissions, had some concerns about whether the policies maybe weren't including them and may actually result in their race hurting their chances of admission. When you hear about things like who's underrepresented, who's overrepresented, and how do you increase representation of some groups without maybe decreasing representation of other groups. But when you looked at a court case that was going on at the time, Fisher against the University of Texas, which Fisher applied to college the same year I applied, there was not really much discussion of the effect on Asian Americans because that wasn't part of the case, and so the judges didn't talk about it, the lawyers didn't talk about it, and so many Asian Americans still had these questions in their mind about how they were treated. And this case of Students for Fair Admissions against Harvard finally kind of brought that issue to the forefront and gave a voice to those concerns. And then as the evidence came out and the litigation happened, more substance was given to those concerns. And so that case went on from 2014 until June of 2023 when the Supreme Court issued its final decision in that case, and they found that Harvard had violated Title VI of the Civil Rights Act and the Equal Protection Clause of the 14th Amendment. And so now we have this wonderful panel here to reflect on that decision. What do we learn from that case? How far did the court go? What are the legal requirements of that case going forward? And what are universities practically doing right now as we're going through an admission cycle to incorporate the court's ruling and to go forward pursuing whatever their missions are in their admissions processes? And so we have a wonderful panel this morning to discuss that. I'll just briefly introduce them and turn the floor over to them. So we'll start with Professor Gail Harriet from the University of San Diego. Then we'll go to Kimberly Robinson from the University of Virginia. Once Professor Riley, if he arrives, turn it over to him at Kentucky State University. We have Stacy Hawkins from Rutgers University and David Bernstein from George Mason University. So I'll start with Gail.
Okay. Well, I've been told that I have 3 to 5 minutes to say something useful here, and we'll see. We'll see. Let me just start with the obvious, and that is that I'm happy about the decision. We haven't won the war, and things could still go awry, but provided that win is defined realistically, the whole thing seems a lot more winnable to me. Yes, universities will attempt to get around it, and by the way, the sun rises in the east, but we don't need 100% compliance for positive things to result from the Supreme Court's decision. Some schools are going to be experimenting with doing away with standardized tests, but I believe that those that hope to be viewed as academically rigorous won't like the results, and some of them will reverse course on that. MIT has already done so after abandoning the SAT in connection with the COVID-19 pandemic. Some schools are going to experiment with social class preferences, as the University of California has been doing for a long time. They're going to find out that there are a lot more low-income Asian Americans and whites than they thought, and that most of their African American and Latino applicants are not what you would call low-income. If they try to get around the problem by defining social class in ways that advantages one racial group over another, they will risk being the target for the next wave of lawsuits, and that wave is surely coming. Realistically, the universities that want to avoid litigation are going to have to begin shrinking the academic credentials gap. By that, I mean the difference at each institution between the entering academic credentials of the average African American or Latino student on the one hand and the average Asian or white student. Currently, as a direct result of preferences, that gap is very large on most selective campuses. Even a small reduction in these gaps is going to help. The most immediate benefit will be better grades as more minority students attend schools where they are academically competitive. That in turn will affect the academic culture on many of these campuses. For years now, critical race theorists have been arguing that academic standards are just a sham, an expression of white supremacy, and struggling minority students had an incentive to believe it. To minority students who are doing well in school, that message is going to ring false. But here comes the caveat, and I'm worried I'm running out of time here already. If those who oppose race preferences just sit back and watch, any gains may be ephemeral. The typical university these days employs armies of individuals who view it as their job to thwart the court's decision. They're already working on it, of course, and that needs to be dealt with. So start with this. Governors need to appoint state university trustees who will ensure that the law is obeyed. It's already happening in Florida. Higher education is just too important to leave these boards to political donors who just want free box seats at the football game. We need serious trustees with their own independent staff. Similarly, state legislatures need to follow Texas's example and cut funding to diversity, equity, and inclusion apparatus on state campuses that helps support race preferential admissions. The amount of money that goes into this is truly staggering. We need to cut off the spigot. Then, careful thought needs to be given to how to reduce the incentives that push universities toward racial preferences. A good example is the Hispanic Serving Institutions, or HSI program, which heaps federal monies on schools with student bodies that are at least 25% Hispanic. Unlike the historically black colleges and universities program, eligibility for which is based on the institution's history, the HSI program creates an incentive for schools to discriminate in order to meet the 25% threshold. The program is almost certainly unconstitutional and should be defunded. Another idea here, accreditors who pressure universities into discriminating, that needs to be reined in. Accreditors should not be in the business of dictating to individual colleges and universities and law schools what the racial makeup of their student body should be. So if the case, students for fair admissions, is to pan out, if it is to be obeyed, we need to be looking at things like this now rather than later. And I suspect my 5 minutes, okay, I shut up.
All right, so good morning. Thank you for having me. I'm very excited to talk with you today, and I'll actually just share a little bit, as Corey did, about my own story. Good morning. So I am the direct descendants of enslaved laborers in my family, and I share that because I have grown up with seeking to understand how that history and how our history of segregation, Jim Crow, and exclusion has impacted our education society. And what we see today is that in both K-12 education as well as higher education, we see a deep underrepresentation of people who look like me, as well as Hispanic and Native American students, in part because of our long history of exclusion and discrimination. And so it is no surprise that when we started to wrestle with this history of exclusion and segregation and lynching and other harms, we began to adopt programs to address the exclusion and the harms that were being imposed. And so bring us today to the SFFA decision. What we have is a decision actually that says mend it, don't end it. Chief Justice Roberts did not end affirmative action, as the newspaper headlines have reported. Instead, what he said is that individuals can speak about how their experience has affected them, and they will no longer merely be, admissions committees will no longer merely be able to rely on a checked box to assess how that experience might enrich the college campus. Instead, students must articulate how their lived experiences, whether that's Corey's experience or my experience, has influenced their reality in a way that will enrich the college campus. So in ways that show perseverance, determination, overcoming obstacles, all of those things are the kind of grit and resilience that help to enrich the college classroom and enrich discussions across issues in colleges. So that's an important thing to understand. The decision did not end affirmative action. I recognize that is not good news in this room, but I want to be clear that that is what Chief Justice Roberts said. Second, I think it's also important, as we recognize the 70th anniversary of Brown versus Board of Education, that we have never provided equal educational opportunity in our K-12 schools. This is why there are so few students of color who are qualified to enter elite colleges and universities. And I'll give you a couple data points. A 2022 report found that 3 out of 4, or 75% of African American students and 71% of students attend schools with less funding that is needed to achieve basically median US test scores. In contrast, 35% of white students and 45% of Asian American students attend these underfunded schools. Now, what does that tell us? It tells us that we have a K-12 system that is geared to underfund particular students. But here's the other thing I hope that you get from that data. 1 in 3 white students are attending schools that are underfunded to achieve sort of average US test scores. And almost half of Asian students are also attending schools that are underfunded to achieve US test scores. And so I think what this reveals is that we have a deeply broken K-12 education system that is not serving many constituencies well. And my hope, and part of my reason just for engaging in the conversation today, is that this decision is highlighting how broken our K-12 education system is, how so many students are disadvantaged by that system, and how we must really, 70 years after Brown, where the court said that education, if it's going to be provided by the state, must be provided on equal terms, we must come to a place where as a nation we embrace that equal educational opportunity principle and build a system that does provide equal education opportunity. And so the SFFA decision is actually encouraging people to focus on the fact that, well, why is there a smaller number of qualified applicants for certain groups? Oh, wait a minute, our K-12 system is broken. We need to focus on fixing that. And that is one thing that I'm particularly excited about from this decision. Despite disagreeing with the ruling, I do think that there's quite a bit of good that will come from this decision. Thank you.
Professor Riley?
All right, good to be here. So let me move this up closer. Apologies for being a bit late. I was downstairs in the wrong hotel for about 10 minutes before I began to suspect this. So glad to be here in the nation's capital. I am Wilfred Riley from Kentucky State University. I'm the author of the books Hate, Crime, Hoax, and Taboo. Great panel from what I've seen of the other participants. And I'm a bit complimented to be, as I understand, the only, by the way, can you guys hear me? Okay, rarely a problem. I'm a bit complimented to be the only non-professor or non-law professor. My focal area is quantitative political science, as some of you may know. And from that perspective, I have a few more structural and social as versus, say, legal or 14th Amendment analytical takes on the fair admissions decision. My first take would be that I think many other political scientists see this case, especially in combination with other things like the recent resignation of Harvard University President Claudine Gay, as a potential bellwether challenge to the entire quote-unquote equity frame across both of our fields. So in my area, many people have traditionally tended to associate quote-unquote wokeness, as it might be called, or the idea of social equity with purely theoretical thinkers like Ibram Kendi, for example, Robin DiAngelo. Dr. Kendi, for example, famously argues that any disparity in performance between large groups in the USA, certainly, perhaps in other societies, indicates racism, the prevalence of racism somewhere in what he would call systems. In fact, I think the argument is that such a gap could only be due to racism or to genetic inferiority. And the solution to such gaps is basically mandating proportional representation of groups regardless of performance, at least until we burn out the hidden racism that's allegedly causing the problem. And of course, in my opinion, this is wrong. There are dozens of cultural and regional factors, at very least, that cause these gaps, and we can, in general, measure these. So to pick something entirely non-controversial, the modal average age, the most common age for a Black American man is 27. For a white guy, it's 58. So among hardline numbers people in poli-sci, this argument has traditionally been seen as almost a silly, non-empirical take. However, as Dick Hanania and others have recently pointed out, this is also basically the rule, or at least has been until recently, in formal US law. So, I mean, I've read the series of cases following Griggs, for example, and the rule essentially is that anything that produces disparity should be assumed to be racist and banned unless it's a bottom line business necessity. So IQ tests are generally verboten. I think we all know that, but I mean, tardiness policies also seem to fail, at least as often as not. Almost every sort of civilizational metric is at risk because almost every imaginable test produces some gap between the 7 or 8 major quote-unquote races, a largely meaningless term, and the 2 different sexes. And the logic saying that the cause of that is bigotry is at root no different from that behind a DEI presentation from, say, Ashley the Lion, who you should look up. So fair admissions in this sort of Chris Rufo context may present the first of what I think will be a series of genuine challenges to that. So the central focus of this case was Asian students claiming that they were being discriminated against at selectives relative to white students, that this clearly had nothing to do with bigotry, and that no claimed interest in diversity can outweigh this. So this may well mark the start of a movement in general. I think that would be more a piece of social than legal commentary. This is probably going to be the next frontier for the US political right. It's at least theoretically possible to argue that achievement gaps between a black American and a white American are due to the subtle but real impact of past bias. But it's very difficult to argue the same thing about the equally sized or larger performance gaps that we see between, say, Mexican American and Vietnamese American women, or Appalachian young men and Nigerian American young men, currently the best educated group in the country. So as another strategic kind of political science sort of...
For the first round, we're going to try to keep it to 5 minutes, so we'll have another round after, so I just want to make sure
Okay.
each person gets enough time.
Fair enough. This is actually the last page of my little presentation. I tailored this to 1 page per minute. But I will say, this whole arena seems like a pretty obvious sort of Schwerpunkt for the political right to target, whether or not you individually approve of that. Far more productive than, say, worrying about calendars online or many other aspects of the US culture war. So, I mean, some questions might be, to what extent could formal and legal equity doctrine be rolled back across sectors? Affirmative action in secondary education, the prep schools, I mean, that's something that's obviously going to come up. DEI offices and diversity departments, ESG, SEL, many such potential targets, as the kids say. Moving on, my next very brief comment is based in the about 10 seconds, is basically my reply to an online direct message that I got when I mentioned that I was coming to this event and what our topic would be. And the question was, what do I think colleges and universities will do in response to fair admissions? I'm sure there'll be many different perspectives from the panel, but I think they will cheat. So basically what I think you'll see is attempts to weight trauma that could potentially be based on racism more heavily. This could be legitimate or it could not. You'll see more focus on the personal letters of applicants. In higher education right now, I've had executive roles as well as faculty ones in higher ed. I mean, we're seeing some interesting changes in the letters that students submit. Perhaps more weighting of the social economic status of the census districts that applicants come from, with perhaps not a focus on Appalachia. So will that succeed? We'll see, and perhaps some in the room will influence that trajectory one way or another. Thank you.
Thank you. Hawkins.
Good morning, everyone. Thank you all for coming out this morning to listen to all of us opine about Supreme Court's most recent decision on race-conscious admissions in higher education. I want to first acknowledge that excuse me, I am getting over a bit of a cold/flu. It is, I assure you, not COVID tested, but I might occasionally cough, so please do not take that as an indication that I am contaminating your event, your room, or your person. I also want to say that I am pleasantly surprised, although we did not in any way coordinate these opening remarks, that Ms. Harriet, I think, had a very practical take on this decision. I'm grateful for Professor Robinson's historical and kind of social context grounding discussion of this decision. Professor Riley, of course, gives us his empirical quantitative perspective. And I'm going to really turn to the doctrinal and legal analysis of the case. That's kind of where my expertise lies. I imagine that there might be some overlap between Professor Bernstein and I in addressing the kind of doctrinal, although from different perspectives. So I just want to offer, I think, a few global observations that struck me as I read and digested the Supreme Court's decision this past June. In the consolidated cases of SFFA versus Harvard and UNC, First and foremost for me, as someone who has dedicated my entire professional career, both in practice and now in the legal academy, to the practice and defense of diversity, I think the most important takeaway for me from the court's decision, and in particular Chief Justice Roberts' majority opinion, is that student body diversity remains an interest that colleges and universities are fully empowered to pursue. The ways in which they are permitted to pursue that interest have certainly been meaningfully altered by the court's decision, but the interest itself remains a viable goal. And I think that that is hugely important, and it's very encouraging to me. However, I do find it troubling how much the court, and again, especially I'm going to call out Chief Justice Roberts in this regard in his majority opinion, disregarded both the record evidence and the findings of fact made by the trial courts in both of these cases in arriving at the conclusion that it was race-conscious admissions plans at both of these schools that resulted in negative discrimination against Asian American applicants. That was based on nothing in the record evidence, none of the findings of fact by the trial court. In fact, contrary to the findings of fact by the district court in the Harvard case. Supported really only by Chief Justice Roberts' own inference about admissions being a zero-sum game. And I don't think that that inference is supported by any evidence, again, any findings of fact, and quite frankly, it's not even supported by logic when you understand how admissions work. I think that his reasoning and analysis also betray, to me, what has become a pattern for him, a kind of increasing, and I have struggled to find the appropriate term to describe what this is. And the only thing that really seems to capture what I think Chief Justice Roberts has done with his racial jurisprudence generally, but in particular in these cases, is to engage in willful ignorance of how race works in this country. But also in particular in these cases about how race works in admissions plans in these selective colleges and admissions. Nevertheless, again, I am buoyed by the fact, as Professor Robinson noted, that Chief Justice Roberts concludes his opinion, nevertheless, with the express acknowledgement that, and I quote, "Nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise." Now, putting aside that this statement utterly, again, misapprehends that race is nothing more than experience with race, right? Like, race is not a biological, it's not a physiological fact. All race is how we experience race as racialized people living in a racialized society. It nevertheless acknowledges the importance of race as a meaningful fact of our life that cannot and should not be ignored, including by colleges and universities. Finally, I want to say that if the court, in the near term, and I think particularly, and Professor Riley just alluded to this, in the kind of Thomas Jefferson High School case that's currently pending certiorari before the court, or possibly even, and this was also mentioned, kind of the more broad attack on diversity, the current case Muldrow that is pending before the court in which there were just oral arguments this past month, and there was some discussion of DEI in that case, in the oral arguments. If in either of these cases or in any case in the near term, the court were to issue a ruling prohibiting the use of even race-neutral means in pursuit of diversity, including considerations of experience with race, which Chief Justice Roberts expressly acknowledged is a permissible race-neutral way to pursue diversity, I think it will betray the court and it will betray the Chief Justice as being motivated in these cases not by the rule of law, but by purely ideological concerns. And I think that that would be deeply troubling, as we have seen with the Dobbs case, because the court's legitimacy is, I think, under attack, rightfully so, I think, in many people's opinion. And what the court will do, in addition to continuing to erode the kind of public perceptions of its legitimacy, is put itself in the same posture that it has found itself with respect to the Dobbs decision, and that is out of step with the vast majority of Americans in terms of the public sentiment, because just as Americans have proved that they overwhelmingly support reproductive rights through various state initiatives that have reaffirmed the belief in reproductive freedom, Americans overwhelmingly support the interest in diversity and the pursuit of that interest across a wide range of domains. And so I think that it would risk the courts a continued erosion of its public legitimacy to engage in an all-out assault on diversity writ large, rather than continuing to focus its efforts on ensuring that the pursuit of diversity is done in race-neutral means, consistent with really what is the only impact of the court's decision in the Students for Fair Admissions case.
Professor Bernstein?
So I thought I would wing it at this point, now that people have said some of the things I wanted to say, and talk primarily about my own special area of expertise within the area of diversity and affirmative action, which is racial classification, which many of you know I wrote a book about. And I think the big lesson with SFFA in this context is that affirmative action was due for a rethinking, whatever your views on affirmative action are, because the original basis for it had eroded as the country changed. And what do I mean by that? So back in 1970, the census that we had in the 70s, of course, the United States was about 82% white, about 12% African American, about 5% Hispanic, but we didn't have a word called Hispanic then. These are people of Spanish-speaking background of some sort, and for the most part, we still consider those people to be white. They were considered white on the census, but they did a study anyway to say approximately how many there were, and then less than 1% combined Native American and Asian American. So this happened to be when affirmative action was really taking off in the late 60s and early 70s, and as Professor Robinson said earlier, the primary goal was to bring African Americans who had been discriminated against so terribly into the economic and educational mainstream. And when you have 82% white and 12% African American, and we had very strong social taboos about interracial marriage and so forth, it wasn't very difficult to figure out who you're talking about and why. Now, it turns out that in 1978, the federal government issued something called Statistical Directive Number 15, which is probably the most influential regulation you've never heard of unless you've read my book. And that is where we get our official classifications from: black, white, black, white, Asian American, originally and Pacific Islander, but they were eventually cut off in 1997, Native American, and Hispanic as an ethnic classification. And the original affirmative action programs didn't necessarily follow this. So if you look at the first case to get to the Supreme Court, I'm blanking on the name, involving the University of Washington Law School, they gave preferences to Filipinos and Mexicans, because those were the groups that were considered to be most analogous to African Americans. In Bakke itself, there were Asian Americans, but there were Mexicans, not Hispanics. Over time, all universities just basically adopted the Directive 15 classifications because they had to fill out that data anyway for the government without any real rationale as to why they were doing it. I actually looked this up recently for a paper I was writing. In the late 1990s, finally, the college app that all the students use, the Common App, changed from having separate Mexican American and Hispanic things to check to it just being Hispanic. Now, fast forward to 2023, we have a population that is now about 7% Asian American, about 18% Hispanic, and Hispanics are about 25% of 18-year-olds, so a very large percentage of the population. In the African American community, it's become much more diverse because you have about 21% of African Americans are either first or second generation immigrants, which was not true back in the 1970s, and you have a lot more self-identified African Americans who have one non-black parent because we have much more interracial marriage. This has really messed things up because even if you believe, yes, we have still this primary objective of bringing African Americans into the mainstream, in 2007 someone did a study, showed that 13% of African Americans at that time were first or second generation immigrants, but they were 43% of the African American students at major, I think it was Ivy League universities. Now 21% is going to be even higher than that. And if you go to government contracting, which doesn't get nearly as much attention as education, but is probably much more important economically, ultimately, because we're not talking about a few selective schools, we're talking about hundreds of billions of dollars of government contracts. There, Asian Americans are included. Anyone who tracks Asian American, Hispanic American, Native American, or African American gets exactly the same preference. It's not a sliding scale as in universities. And it's very hard to get data on it, but the Wall Street Journal, prompted by something I wrote, FOIA'd the Department of Transportation and found that only 18% of the dollars that were going to federal construction contractors based on minority business enterprises were going to African American owned businesses. And if you want, we don't have data on this, but I suspect that if you divided that data, you get significantly less of was actually the American descendants of slavery who these programs were meant for, as opposed to first and second generation immigrants. And frankly, I've spoken about this issue many times, and I've yet to find anyone, no matter how enthusiastic they are about affirmative action, who agrees with the proposition that someone who came here from Bangalore or Mexico City or Buenos Aires, lives in the United States for 5 years, becomes a citizen, should be getting a preference in government contracting, but no one's really reconsidered this ever since. So in SFFA itself, Chief Justice Roberts talked about the classifications being arbitrary, over-inclusive, under-inclusive. Chief Justice Gorsuch, in his concurring opinion, went into much more detail about that, and that was cited favorably by Roberts. So I think that there is still room, as some of the other panelists said, for looking at diversity in a variety of ways, but I think one really novel aspect that almost no one was expecting, and I wasn't even really expecting them to address it because they hadn't before, is that yes, if you are going to show a compelling interest in diversity, or if you are pursuing diversity in a way that does not otherwise violate the Equal Protection Clause, you still have to give us a rationale of why you're picking out these groups. You can't just say that in 1978 the government decided that Hispanics are members of a minority group and therefore they're automatically eligible for everything without giving any rationale of why a Italian Argentine who comes to the United States gets a preference, but say someone from Yemen or Armenia or a refugee from Bosnia does not. So that's going to be an interesting angle that we'll see what comes of it.
Thank you, Professor Bernstein. I'm going to ask a couple of questions for the panel, and then maybe everyone one last chance to kind of conclude and give some responses to everything they've heard, and then we'll turn it over to the audience at the end. My first question goes off of something Professor Hawkins mentioned, which is race-neutral criteria. I think it's clear that from the majority opinion that there is room left open for differently tailored ways that don't look at race or are different than kind of the way they've been historically done, and yet are still trying to achieve some of the similar objectives. At the same time, we also know that much of race discrimination litigation in various other areas of society, whether voting, housing, a lot of that focuses on purportedly or facially neutral policies, which yet may give rise to an inference of discrimination based on whether the effects that it has, as well as perhaps the intent of the policymakers. And so can you talk a little bit about what you see going forward, both maybe what's actual things that you're hearing about schools doing or that have been talked about, kind of your thoughts on what may be lawful under the court's decision and what may venture into the realm of purportedly neutral but actually discriminatory. We'll just maybe start down the panel in the same order.
Well, I mean, certainly it's the case that there can be facially neutral qualifications that are in fact intended to have a racial effect. And just like in Title VII, the jurisprudence, if the qualification is a pretext for race discrimination, then it's still illegal. And a case that it is nine something. Right now, the Supreme Court, I believe, is meeting about whether or not to take the Thomas Jefferson High School case. There is a petition for cert, and it will raise this question of clearly intentional, because the school board said, we've got too many Asians, what are we going to do about that? And they changed the qualifications on that basis. We'll see what the Supreme Court does. I look forward to that decision.
Yeah, so I think that it's clear that colleges and universities do use a variety of race-neutral criteria, and that they will continue to look at what those are. I think what's important about SFA is that the commitment to diversity that has arisen as affirmative action has existed, to continue to have diverse campuses. The colleges and universities now are also looking at factors that have had a disproportionate impact to exclude particular minority groups. And those two factors are legacy and being the child of a donor. So those groups get quite significant bumps in admissions, and the SFA decision, because it's making admitting a diverse class more difficult, are actually causing universities to say, well, perhaps we should start to remove these preferences that are making it harder for us to get to a diverse class. In terms of, racially neutral criteria that universities are considering, socioeconomic disadvantage is certainly going to be one of them. But I do think that as well, this demonstration of the things I talked about in my initial remarks of perseverance, grit, and overcoming obstacles are going to be given increasing weight in applications, in part because, all of this is a highly educated audience. All of us in college had to persevere, demonstrate grit, and all of those things. And so sort of looking for those criteria within the population is something that I think universities will start to focus on more as they move forward.
Yeah, I'd agree with a lot of what's been said so far. Two very quick notes before my comment. First of all, Professor Bernstein might correct this by a point or two, but my understanding when you talk about those government contracting figures is that 18% of all expenditures, that was the statement, went to black-owned companies. I believe it was 4% when people have tried to unpack this, went to quote-unquote ADOS, companies owned by American descendants of slaves. So that is the real challenge in today's world, I think, to these affirmative action and diversity forward programs. The largest beneficiary group for affirmative action, leaving aside the debate about Caucasian women and so forth, is Hispanic Americans. The USA right now is 18% Hispanic. It's about 12% black. So the question is how you can justify the programs in that context. And that's, for supporters of affirmative action, that is a challenge that has to be met. As read Dr. Robinson's comment, I would agree that the existence of legacy programs is probably the best remaining argument. There's nothing particularly wrong with diversity forward programs. My impression is that sort of the standard position on the center right is that people would be glad to see legacy programs go as well. But the audience may comment on that. But,
Except for while I went to school.
Yeah, for my son, of course. I'm in that age now where they're just being born. But at any rate, though, that, and of course, there we see the challenge, right? But in a sentence, I would agree that it is very, very difficult to prevent an academic institution working at one, particularly a private academic institution, from using the techniques that they want to admit students. I mean, in one sentence, I get the impression that the test prep organizations are now telling applicants to focus perhaps on a troubling experience with racism or a personal struggle story. You simply weight the letter more. Even under the old system, quotas, verboten, goals allowed. I'm a member of the University of Illinois Alumni Association. I mean, that goal every year resulted in the admission of usually 9 to 11% upper middle class African American students from the state of Illinois. So I don't necessarily think you're going to see dramatic near future changes. We'll see.
So before I comment specifically on this idea of race neutrality, one of the chief aims of my work is to really try to disentangle what is traditionally understood and has been practiced as quote-unquote affirmative action and the contemporary interest and pursuit of diversity. And so, again, I thank Professor Robinson for giving us the historical context of what these programs were designed to do at their origins, but they are designed to do something very different today, right? And so when Professor Bernstein talks about why are we not accounting for whether or not, right, the only people who are benefiting from these current programs are people who experienced historic discrimination, that's not what these current programs are designed to do. So if you go back to the Supreme Court's 1978 decision in Bakke, the court expressly prohibited colleges and universities from using race to remedy past discrimination. That has not been the justification tradition for the use of race in admissions since 1978. Instead, the court only endorsed, and much to, many people's chagrin, a forward-looking kind of instrumental interest in student body diversity that they said would generate educational benefits for these institutions consistent with their First Amendment interest. And so I think that we really need to be mindful of this disjunction between past historic traditional affirmative action programs and diversity interests of today. There does not need to be a match between what's being done today and the origins of affirmative action, because they're very differently conceived, justified, and implemented. The second thing about race-neutral efforts, and again, I just want to reiterate that I think it will be deeply problematic if the court engages in what I think many people will view as a bait and switch, because Chief Justice Roberts was very clear that the diversity interest is an important interest for colleges and universities, and they ought to be allowed to continue to pursue that interest so long as it is in race-neutral ways. If the court were to now turn around and say it is the diversity interest itself that is impermissible, I think that that would be deeply problematic, not only because it is directly contrary to what the court has just said in 2023, but again, it goes against the weight of public opinion about the critical importance of diversity to our kind of democratic ideals about equality of opportunity across a wide range of domains, not just in higher education, but in K through 12 education, especially in these, selective competitive magnet schools, as well as in higher education, in employment, in contracting, in our elected and other representative positions in our democratic institutions. And so I really do think that it is not appropriate for, as Justice Sotomayor said, for the court to continuously move the goalpost every time we get close, right? And we devise a strategy for pursuing what we all agree is a legitimate end. I just think that that's not the way this ought to develop.
Yeah, so one thing about the diversity point, which Professor Hawkins says is correct, is the rationale that it's still the issue, like, well, to the extent we're looking at diversity and we say, well, we are putting Asian Americans into one diversity classification, no one would ever do that if they actually were interested in diversity, as opposed to we just have to follow, doing whatever we're doing, because the category of Asian American includes, for example, Bangladeshi Muslims and Filipino Christians. And to the extent, what common thing are they adding to the university other than government bureaucracy decided in 1978 that they belong in the same statistical classification, largely because there weren't enough Asian Americans in 1978 to think about dividing them. Well, it's only like 1% of the population, so what are we going to do? And and South Asians almost wound up in the white classification. There's a whole story in my book about that. It's just sort of arbitrary that we put them in the same classification as East Asians and Austronesians, which is what Filipinos mostly are. So the classifications need work. It would have been nice for universities if they had said, yes, we've actually sat down and thought about that, and here's the study we did of which kind of groups. But no, they just sort of naively, partly because who wants to figure out exactly what groups would actually add to diversity that could cause its own problems, but they just sort of naively use these classifications, which makes it hard to defend. On the issue of race neutrality, I've heard conservatives occasionally say, well, you can't do things that are motivated by race or have that will have racial effects. That has to be wrong. That just has to be wrong. Civil rights laws are motivated by trying to, they are facially neutral in the sense like if you're white, you can sue. If you're black, you can sue, whatever, on race. But everyone knows that the main reason that the 1964 Civil Rights Act passed was because we wanted to redress discrimination in public accommodations and employment, primarily, though not exclusively, for African Americans. That can't be unconstitutional. That's a permissible government interest. So the question is, And one reason why it may be different when you're favoring white people over favoring over doing things that you know may help minority groups is that something like integration is a legitimate government interest. It's not required if it's not de jure to overcome it, but it's legitimate to say, oh, we're figuring out where the boundaries of the high schools are. These are two different options that are very similar. Maybe option A is a little better on overall, except for the fact that option B would lead to more integration. Could you say that the government can't do that? Because no, because that's still a legitimate government interest, and they're not classifying anyone by race, not trying to harm anybody. So I think the issue of where that line is, though, is an interesting one. I think in the Thomas Jefferson case, it's not a legitimate government interest to say we have too many Asians, reducing the number of Asians per se. So there's enough in the record there that I can't imagine that if this gets to the Supreme Court that they're going to say that they could just rule on that basis. They don't have to go any further. At what point do you say things like percent plans or looking at zip codes that we know are going to lead to integration would be illegitimate? And interestingly enough, I haven't taught civil rights law, but I teach constitutional law, and there is a doctrine from a case from 1985 that says if a law has discriminatory intent and discriminatory effects, it's unconstitutional. But how much intent do you need? It can't be that if one member of the public or even one member of a 12-member city council says something discriminatory or racist, that is enough. But on the other hand, it has to be some line where you say this is, but there is no good case law on exactly where that line is, as far as I could tell. It does seem but it seems like it's something like it has to be the predominant motivation. That race has to be really what you're thinking about, or other classifications. So I think in the educational context, what will come down to is, can you make a good case as the state that, now that you said affirmative action is illegal or limited, it made us look at our whole system and make reforms. And yes, one benefit of these reforms will be more racial diversity, but that's not the only or maybe the primary reason we're doing it. So the 10% plans are a good example. These were passed in Florida and Texas with overwhelming support from Republicans, which I think from a political basis means the Supreme Court's less likely to think it's illegitimate, right, because it's their side doing it. But also, state legislature said, hey, while we're rethinking our system, why is it that all the resources of these state universities are going to people who live in the Austin suburbs and the Houston suburbs and the Dallas suburbs? What about my constituents going to my rural high school or the inner city high school? Why shouldn't they get a share of the state resources? So yes, this will increase racial diversity, but will also benefit my constituents and have more socioeconomic diversity and so forth. And I don't think that the Supreme Court is going to say that that's illegitimate. I'm not saying you'll get 9 votes to uphold it, but I don't think you'll get 5 to say you can't do it.
Thank you, Professor Bernstein. I'll ask one more question, then give everyone a chance to make some closing remarks. I want to share a little anecdote. I remember when I was a law student, I saw a debate between Gail Harriet and Professor Randall Kennedy when I was at Harvard. And an Asian American student asked Professor Kennedy, what do you think Asian Americans might have claim to certain harms of discrimination? And one other anecdote, I was watching an interview that Adam Mortara did. He was one of the trial lawyers in the Harvard case, and he actually kind of described how he made the decision to accept the case and litigate it. And he mentioned actually, because I'm white, this issue never really preoccupied me that much. I figured whatever harms might be imposed, it's distributed broadly across a large percentage of the population. And kind of as myself looking at these cases and thinking about them, it's one thing to say we're comparing you against the majority population that makes up most of America anyways, versus, say, an Asian American actually comparing them against other people who are a relatively small percentage of the population. And so the question kind of has to go to, what role do you think the Asian American perspective brought to this case? And going forward, as we try to figure out as a nation, what is kind of the stable ground, if any, that we can find how to govern ourselves in terms of our civil rights jurisprudence? The people who are in the hot seat, the decision makers, the university administrators, right, who are hearing all these competing personal narratives and claims of different groups with different life experiences, different generations, and what's the vocabulary that they need to articulate, what their goals are, what's the right thing to do here, and practically how do we do that in a way that brings in and makes sure everyone feels included, including groups that maybe haven't been thought of as much in these discussions before.
Well, I do believe that the Asian American perspective has been important in the SFFA case. There is a reason that the people who were backing the lawsuit wanted it to be Asian, and that is that it forces people to think about the complexity of the issue. That, in the past, it was a little bit too easy to fall into a privileged whites versus unprivileged African Americans, and that's the way the world is. And that's a cartoon version of the world. The world is ever so much more complex than that. And it's not just Asian Americans, there are all sorts of different groups that we hardly think of that are advantaged or disadvantaged under a racial preference system in ways that are complex. We do not live in a world that is just black and white. We live in a world that is multi-ethnic, multiracial. There are people who are privileged, people who have had a hard life in every single one of those groups, and it's complex. And for a lot of people who, I guess like Adam Mortara, who hadn't thought about it much, this forced him, a very, very talented lawyer, to think about the complexity of the issue. And I think it forces a lot of Americans who maybe were thinking in the cartoon world of black and white, that the world is complex. And systems under which one's race or ethnicity counts in favor of one's admission to an elite university. That's not a world that I want to live in, and I think that Americans have agreed it's not a world that they want to live in either.
So a couple points. One, the survey data actually shows that Asian Americans, which is a very broad category, admittedly, actually support affirmative action in terms of the statistical majority. So if you survey a broad cross-section, the data actually shows that Asian Americans support affirmative action. So I just want to start with that point. Second, I do believe that college admissions officers, as they are seeking to address and continue to pursue diversity, which they will start to recognize the diversity within the Asian population. In other words, sort of making sure that we have a broad cross-section of Asian Americans to include in universities is to the benefit of the students as well as to the broad demographics within that category, which may ultimately, perhaps the government will eventually disaggregate that some. But, including students, for example, who are Hmong, who are Filipino, who come from just different backgrounds will enrich the experience just as, getting students from different Hispanic backgrounds, whether they're, Mexican American, they're descendants from Argentina, from Spain, all of these places have a different story, a different history, and a different lived reality that you then bring to the conversation. And one of the reasons you have not only higher education, but also US businesses who came out in favor of affirmative action is because there is a business case to be made for diversity. And that is that when you bring people together across differences for problem solving, for marketing, for all of those things, you then have results that show that you have a more inclusive and more impactful and even more profitable approach to the operation of your business. So I think that this will cause many admissions officers to sort of reflect more on, we did have quite a crude category, and now we can think about how has the lived reality of these students impacted their lives and what can they bring to our college campus. And I'll just end with this story. Like one of the, first it's important to understand that one of the biggest beneficiaries of affirmative action, the biggest one the data shows is actually white women. White women have been the biggest beneficiaries of affirmative action. That is what the history shows. And the second thing is to understand that when we look at building a diverse class, we have to understand that we have a K-12 population that is majority students of color. So public schools in the United States are now majority students of color. So the future of our nation is going to continue to be a diverse one. And so this idea that we could kind of roll back to a time where elite colleges are only made up of a select number of groups is just not possible in a nation that is increasingly diverse, just demographically, just the sheer numbers. And so really this debate is about who is going to be in positions of leadership, power, and influence, because that's what the elite colleges are really preparing students for. And as we have an increasingly diverse nation, continuing to have diverse leadership and students who can engage with people unlike themselves, just like we're doing on this panel here today, is something that's really important for students to learn to do, particularly because K-12 schools are quite racially isolated. You often don't engage with students who are not like yourself in your K-12 school. And so colleges sometimes are the only place to prepare for that lived reality when you enter the workplace. And so that is one of the reasons why U.S. businesses came out in the affirmative action cases to support diversity, and why universities will continue to push for broadly diverse institutions.
So, I mean, in terms of the core question, I think it was absolutely revolutionary that fair admissions was brought by an Asian American group of plaintiffs. I mean, just looking through the case from, again, my out-of-field perspective, these seem to be the most academically qualified applicants involved in any recent affirmative action case. They weren't white, so any kind of starting position of relative non-sympathy didn't exist there. In fact, one of their major claims, if I recall the case, was that they were facing discrimination not just relative to African Americans, but relative to whites, which is accurate. There's not really a white and Asian category when it comes to this test scoring data. You see that a lot on the right and on the left. I mean, in academic admissions, you really see three student populations, bluntly. I mean, so you have natives, African Americans, and Latinos, and those SAT scores, last I recall, this is 2021, were 929 for natives, 943 for African Americans, 961 for Hispanics. None of these are god-awful. The average was about 1,000 when I went to high school. However, you then have Caucasians, whites, at 1,100, and you have Asians at 1,233. That's across the entire Asian group. So there's really not a lot of competitive comparison there. So the Asian case was against everyone. And they countered a lot of the points that we've been debating at this table. I mean, again, the point was there were 27 groups, I believe, Professor Bernstein might correct this, but classified as Asian American, very diverse population. There's no argument that an Asian white gap on tests is due to any kind of racism. We don't live in a Korean supremacist society. So I think this was a very, very tough case to logically counter, just speaking strategically. And I will note, by the way, these gaps that we see in testing are enormous at the better selectives. I mean, I read the quantitative materials that were attached to fair admissions. I mean, the overall academic index that would get an African-American student a 95% chance of admission to Harvard, no one's guaranteed admission to Harvard, but would get an Asian American student positioned with about a 21% chance of acceptance to the university. All these students, again, are quite good. I want to emphasize that. But African American average SAT at Harvard's 1408. Asian American is 1566. So, you're picking from the elite, but there's still an obvious argument of discrimination when you look at these 150-point gaps. So I think that was a very, very tough case to counter. By the way, some interesting things. It looks like if you break out Nigerians and other West Africans, they do about as well as Asians. Some interesting stuff there. These are cultural and social differences that exist for various complex reasons, as everyone's mentioned. Past racism is certainly one of these. But in this moment, it's very hard to argue that the Asian guy who gets a 1250 applying to, say, Purdue should be disadvantaged relative to the Caucasian guy who gets an 1100. And that was the strength of that case. As a final comment, Dr. Robinson and a couple other panelists have said this. This is correct, by the way. This is correct data. Asian Americans overall say they support affirmative action. My one caveat there would be that everyone says they support affirmative action if you just phrase the question as affirmative action. If you were to ask people, and I don't know, I haven't seen this done in the past 4 years, but if you were to ask Asian Americans specifically, the average Asian test score on this exam is 1230. The average Hispanic score, there's no reason to bring whites and African Americans to this at all, is 960. Should the Hispanic applicant for most of these slots be treated equivalently to the Asian applicant? I mean, I think you'd see 15, 20% yes rate. So a lot of that has to do with question wording and perception. Many Americans still believe that affirmative action means a slight hand up among two equally qualified candidates. At the top schools, that is often not true. Again, you have, sorry about that, one clade of minority students. You have white students in the middle, they're not outperforming. And then you have that huge and diverse Asian American group. It's now 7% of the population. Again, I'm not making policy here, but something, what we do about that has to be figured out.
So a couple of observations, and again, limiting the commentary to the kind of role and significance of Asian Americans being the plaintiffs, in particular the Harvard case. Let's be very clear, we're talking about the Harvard, not the UNC case in this particular instance. So first of all, I do think that it was kind of an important public acknowledgement, although as someone who has done educational equity work for a very long time, all of the data and research kind of disaggregates Asian and white on the one hand and Black and Hispanic and, you know, to a much lesser extent often Native American students on the other hand, right? And so this dichotomy between white and Asian on the one hand and Black and Hispanic on the other hand has been a long-standing kind of, I think, demarcating principle in issues of educational equity. I don't think it was newly introduced in the Harvard litigation. But again, because of that known kind of dichotomy, Asian Americans made for an easy target for SFFA to solicit, to participate in this litigation. The other thing is that, again, this finding by the Supreme Court that Asian Americans suffered from discrimination in the admissions process was simply not supported by any of the record evidence in the district court case. And in particular, and what is the most troubling, is that any evidence of disadvantage at all in the admissions process that was acknowledged in the trial court finding of facts was not attributable to the race-conscious admissions plans. It was attributable instead to things like legacy, athletic, donor, and faculty, children's preferences, and perhaps to these alumni interviews in the Harvard case. Again, none of which have anything to do with the way in which Harvard was using its admissions committee to conduct race-conscious admissions. And so there is a huge mismatch between the plan of race-conscious admissions that both the plaintiffs and the Supreme Court attacked as the source of any injury to Asian Americans and the actual record evidence in this case. I think that, again, to this point about differential test scores and that being some sort of compelling and unassailable evidence that Asian Americans had a very strong case, again, it misapprehends the way admissions works. There is no selective school that admits students purely on the basis of academic credentials. Harvard itself admitted it could have an entire entering class of students with a 4.0 and a 1600 on the SAT, but they choose not to do that because those academic credentials are not all that matters. That is not the only consideration that weighs into the admissions process. And to treat it as if it is to entirely miss the point of what's happening. And that's the reason why the court got it so wrong in talking not only about this kind of zero-sum calculus of admissions, but also in presuming that all Asian Americans are treated similarly in the admissions process, even with respect to the race-conscious considerations. And so I have worked over the last several years with both the Legal Defense Fund and the Lawyers Committee for Civil Rights, both of which represented student interveners in these cases, some of whom were Asian American students who attested to their own experiences benefiting from the consideration of their race in the admissions process based on their describing, as Chief Justice Roberts has said is continued to be permissible, their experiences with race. And so there are wide differences in terms of as Professor Robinson said, access to high-quality K through 12 education, as well as the ability to usually take advantage of test prep and other resources that give you an advantage on the SAT. And so there are widely divergent experiences. And in fact, the record evidence demonstrated that Harvard, as well as UNC, but in particular Harvard, when we're talking about Asian American students, they were taking account of that. And because of that, there were many Asian American students who benefited from the consideration of race in their admissions process. Finally, I want to say on this point about the Asian American category, the classification itself being illegitimate or inappropriate. And I happen to be editing a special issue of the Journal of College and University Law that is going to come out later this month that is dedicated to the Students for Fair Admission versus Harvard and UNC cases. And there are a number of contributing authors. I hope that those of you who are interested in this case will take the time to read those contributions. But one in particular comes from a group of social scientists who submitted amicus briefs in the Harvard litigation. The authors in particular who contributed to this special issue, not only are they themselves social scientists, but many of them are themselves Asian Americans. And they talk about, again, how the court simply fundamentally misapprehends what race is, right? Race is not some sort of biological or physiological fact. The reason why Asian Americans are lumped together, the reason why Asian Americans, at least many of them, and certainly the social science literature supports the validity of the racial category Asian American is because of a shared racialized experience that is common to Asian Americans in this country. I mean, I think that we can all recall in the aftermath of the kind of COVID when it was first announced, there was a huge backlash against Asian Americans in this country. And people were not taking the time to figure out whether or not people were of Chinese descent or Korean descent or anything else, right? It was just an anti-Asian sentiment. And so there is and has been a longstanding recognition both within the Asian American community, but sociologically, that the Asian American racial group is a legitimate one that reflects a shared historical, racialized experience on behalf of Asian Americans. Is it ideal? No. Does it paper over lots of differences? Absolutely, but so do all the other racial categories, right? They are necessarily imprecise and inelegant tools, but they are the only ones that we have. And those are the ones that colleges and universities use specifically because they're used by the Department of Education, right? And other government bodies for census taking and other data collection. And so there is an ease of operationalizing their interest in diversity by using those categories. So I'll stop there.
So first I want to a little bit take issue with something Professor Hawkins said. I mean, I think that's true. The district court didn't find that there was anti-Asian discrimination by Harvard, and I don't think that there was like direct evidence like, oh, we are, there's some smoking gun, we're trying to limit Asians, but there is this really suspicious statistic that in 1990, the entering class at Harvard had been going up gradually for years, and then it hit like 20%, and that basically froze until 2015, which is when the litigation started, and it was 21%. Which doesn't sound bad, except if you consider that the Asian American population was not only growing dramatically during that period, but more important, the percentage of the number of Asian Americans who had been born in the United States and therefore English was their first language, and therefore be much more likely to be qualified to go to Harvard, not because they were native English speakers, and obviously it's easier to do well in school, had gone up. I don't have the exact figures, but a lot. Let's just say, and the odd thing about it, or maybe not so odd, is that this is true across the Ivy League, that they all kind of hit a plateau when the Asian American population hit around 20% of their schools, and that seems like a very odd coincidence that if there's nothing planned there that this would be odd. Now that said, I should also say that the category does give me a little bit of heebie-jeebies because I do think it's a pretty arbitrary classification, but not just because it includes people from dozens of countries that compose like 60% of the world's population, but also I discovered in my book, most people who we call Asian Americans don't think of them, not only don't think of themselves as Asian Americans, don't want to be called Asian Americans. Now, we're used to this in academia. I'm sure if you talk to law professors, you'll get a different story but it was fascinating to me. The Hispanic and / Latino classification was kind of a newfangled category in the 70s too, but it's actually come to be accepted by people we call Hispanic and Latino. Most of them will say, I prefer to be called Mexican American or whatever, or other hyphenated Americans, or just American. But if you want to call me Hispanic or Latino, 90+% say that's fine. If you ask Asian Americans, what we call Asian Americans, only about 40% say they accept it as an identity at all. They do not want to be known as Asian Americans. And, I think that, yes, there is a history of people not distinguishing between Chinese and Japanese, but we're a different country in 2023 than we were in 1970 by our sophistication. I don't go to the Asian restaurant for lunch. I pick out from the Thai restaurant or the Indian restaurant or the Chinese restaurant. When I go to the nail salon, I don't think I'm going to the nail salon. Oh, the people who work there are Asians. I understand that the Vietnamese very probably are speaking Vietnamese around me as they cut my hair or do my wife's nails and not speaking Asian. And it's a little bizarre to pretend otherwise. And in the university context, I should say that it's not Asian Americans who are quote unquote overrepresented, a term I don't like. It's really the two largest populations of Asian Americans, so-called, are Chinese and Indian Americans, and they are also the ones who are wildly disproportionately, quote-unquote, overrepresented in school. Koreans and Japanese to a lesser extent, but they're relatively small groups. But then Cambodians, Laotians, Hmong, Vietnamese, Filipinos, and so forth, they're doing more or less what you'd expect percentage-wise of their population. It's not like there's some special Asian thing where Asians are all succeeding. It's a culturally and otherwise and dependent on all sorts of these sociological factors I'm not an expert in. Finally, I want to say that I think that taking the sort of very high-level point of view on this, that one distinction between what I've been thinking about this and what I read in a lot of my fellow law professors' literature is that the other side, shall we say, seems to think that even though race is socially constructed, it is a permanent, indelible feature of American life that can't possibly go away, and that it's not even clear, certainly not for African Americans, but not for Asian Americans or Hispanics, if we want to put that into a racial category, even though it's not either. And therefore, we just have to do what universities, governments, and big corporations are doing, just divide people into these classifications and make sure everyone gets their share. Now, I'm not saying we shouldn't make sure everyone's being treated fairly, but I don't like that as a goal, a future goal. I don't think it's necessary. I don't think it's proper. Randy knows all about necessary and proper. The goal should be to have, I don't know if you want to call it a multiracial society, a non-racial society, and this is not, color blindness, which is now criticized. It's not saying that no one's ever going to recognize that people look different or have different cultures, right? But we have a situation. Just consider this example I like to give. Consider 1960, that we had really serious divisions in the United States between people who are Catholic and people who are Protestant. We don't remember this anymore. I wasn't alive for this. It seems silly to me, ridiculous. But it was a big deal, right? In the 1920s, the KKK was the most powerful political organization outside the political parties in the United States, and their main thing in those days was anti-Catholic. And they got a law passed that basically banned almost all Catholic immigration to the U.S. People didn't know, would people vote for JFK in 1960? And the answer is no. He won, but he won because even though millions of Protestants wouldn't vote for him, who are normally Democrats, millions of Catholics voted for him, who had voted for Eisenhower because it was what we now call identity politics. They thought, underprivileged minority, we want to get our guy in. So, go 2020. Imagine someone's in suspended animation or in a coma, wakes up in 2020. You tell them, oh yeah, we just elected a Catholic president, a female Catholic Speaker of the House, Jewish Senate Majority Leader, 6 Catholic justices on the Supreme Court. By the way, the vice president is a mixed race, half Asian, half black woman who self-identifies as black. I mean, could you imagine First of all, the first reaction would be, what? The Catholics are running the country? That's impossible. You couldn't imagine that in 1960. And then, everyone else, there's two Jews in the Supreme, there's like no Protestants on the Supreme Court, basically. The country was run until 1960 by Protestant white men. That was it. That was the only. And the idea that in 60 years there'd be like no Protestant white men running the country in these high levels would have been completely impossible to conceive of. And when it just happened naturally, no one even notices. It was completely uncontroversial. Does anyone even care? Like Ron DeSantis is Italian. Remember, some of us are old enough to remember. Not that long ago, when Justice Scalia was appointed to the Supreme Court, it was a big deal. First Italian American. No one cares anymore. So that's not to say you can't be Catholic. You can't be a religious Catholic. People recognize you're Catholic. People respect that you're Catholic or not, as the case may be. But not that we're taking away your identity, but that it doesn't affect your life prospects, essentially. No one thinks, oh, well, you're Catholic, so you can't do this. You're Jewish, so you can't do that. And that's what we'd like to have in the future for race in the United States and ethnicity. That it's not that that you can't belong to your Black students organization or your Latino club or whatever it is, or your Chinese mahjong club, or if you're Jewish grandma, do the same. But in any event, that should be the goal: is to make race not sufficiently salient that your life prospects depend on it. And I'm afraid that if we just insist on continuing to classify people by these crude racial classifications, even when we don't really have any firm goal in mind, but it seems the thing to do, we're actually not only retarding progress, that may be a self-fulfilling prophecy if those classifications become calcified and we never go past it.
Thank you. I guess since Asian Americans were mentioned, it's interesting. My reaction to the category is on the one hand, Professor Hawkins, I remember when I was in high school, probably the closest friends were Indian, and in a way we had some kinship because we were both relatively small minorities. There weren't a lot of people like us, and our parents were immigrants, and I think in that way we did have something in common. And at the same time, I don't think I understood much more about his language or culture any more than white Americans or anyone else. And so I think the Asian category was perhaps something, not one that I would have wanted, but it perhaps in some sense did capture that aspect of just the immigration patterns of this country and how that's played out. And I think one of the great things about this case has been the chance for Asian Americans to share their stories and to interact and to see how going forward we can come to a better understanding of how we govern ourselves in a way that's genuinely inclusive of all people. I've had a chance to talk to Ted Shaw and Randall Kennedy at these types of events, and I feel very fortunate, and I think it was productive. I think by the end of me telling kind of my personal story, they maybe saw an angle that they hadn't quite appreciated the depths of, even though I don't think I changed their policy view on anything. And I think at the same time also for myself, as a young person kind of frustrated and wondering why Asians were being ignored, I gained a better appreciation as well of those who had come before, for whom certain parts of history really didn't seem that long ago. That was anybody, a current justice, Lennox Hagan clerked for Thurgood Marshall, and who himself, it doesn't really seem that far long ago. And how do we continue to have these respectful conversations to come to an understanding of what it means for a society to be genuinely inclusive? So I'm grateful to all the panelists for this discussion. I guess we're coming up near the end, so I do want to leave some time for question and answer. We have 2 microphones over here if anyone wants to get ready. I do want to give everyone a chance to kind of conclude, but maybe, if it's just 1 or 2 minutes briefly, if there's any last thoughts you want to share with the group.
Okay, I've saved up a bunch of issues here. One is that I agree with Professor Robinson when she says that one of the effects of SFFA is going to be a renewed emphasis on what's going on in K through 12. And you won't go very far wrong if you think that what's happening today nationwide is similar to what happened to California in 1996 when Proposition 209 passed. You got that emphasis on K through 12. For example, the UC San Diego campus started the Prus School in response to Proposition 209, which prohibited racial preferences in admissions, among other things. And the school's done pretty well. And I'm hoping that that's going to happen nationwide, that there will be renewed emphasis on K through 12. Clarifying the funding situation, it's basically U-shaped, and that is students in the middle have less spent on their K through 12 education. Now, arguably, schools in low income neighborhoods need more funding, but in fact, it is a U-shaped curve. Number 3, on legacy preferences. Just a story here. Yeah, I think it's true that in general, conservatives on this issue are also anti-legacy preference. Ward Connerly, the UC, University of California regent who chaired the Proposition 209 campaign in 1996, brought before the Board of Regents the legacy issue. He was very much against racial preferences. The rest of the board was split. He brought up the notion of why don't we get rid of legacy preferences at the University of California. It's split just the same way. Those who wanted racial preferences also wanted legacy preferences. Those who were against racial preferences were also against legacy preferences. They were concerned with a state university, that some of them might have a different view with regard to private universities, but I will not cry if legacy preferences are gotten rid of. In fact, I will cheer. Number 4 on my list here had to do with something Professor Hawkins said about the Supreme Court being out of step with the country on the issue of what she called affirmative action. I know a lot about the polling on these issues. I've been following it for 30, 40 years now. It is overwhelming that when people are asked about actual race preferences, as opposed to amorphous terms like affirmative action, they are against it. It is not a close case. With regard to affirmative action, when I am asked that in a poll, I also favor it. I favor beating the bushes to make sure that everybody is aware of the opportunities available to them. That is affirmative action to me. And so, yes, I am for it. Am I for diversity? I would answer that one yes, too. But you cannot go wrong if you figure that these polls here that make it clear that we're talking about issues of giving preferential treatment based on race, even when the best arguments in the other direction are presented. Americans are against racial preferences in colleges and universities. And just 3 years ago, there was an effort in California to repeal Proposition 209, and the legislature, it was a referendum, the legislature thought that, well, we're now a majority-minority state, we're much more progressive than we were 25 years ago, we're going to repeal this nasty Proposition 209, and boy, did they ever get it thrown back at them. The opponents, and I co-chaired the campaign, the opponents of that referendum were outspent more than 14-1. We had very little in the way of funding, but we beat them overwhelmingly when Americans or when California voters were presented with, look, this is what they want to do. They want to repeal the part of the Constitution that says the state shall not engage in discrimination or preferential treatment based on race, sex, color, ethnicity, or national origin. And 57% of Californians voted no, despite the fact that we were massively underfunded. That is completely in keeping with what the polling data over the last 40 years shows. It is not a close case. As for Asian Americans' views, again, just like any other American, if you say diversity or you say affirmative action, they're thinking much more broadly. Our volunteers in the Prop 16 opposition campaign were overwhelmingly Asian American, and each and every one of them that I met, and I met a lot, would have walked through fire to make sure that Prop 16 did not pass. The notion that Americans support racial preferences in admission is just not true. The Supreme Court is very much not out of step with American opinion. Not that the Supreme Court should be governed by American opinion on all issues, but they are very much in keeping with American opinion on this issue, as even the New York Times has conceded.
May I just correct the record? I'm not going to go out of order, but can I just say that, Ms. Harriet, I said American public opinion on diversity. I never said affirmative action. I never said racial preferences. I said diversity.
Well,
there's a difference. There's a divergence in opinion.
You also said that the court wasn't against
support.
diversity, and therefore that's not If the court hasn't held that diversity is a bad thing, then how is that out of step?
But I said that they have suggested that they might be, right? Like there's some indication that could be where they move. And I said, if they do that, they will be.
Sounds like
For
they're
right
in
now,
step.
they are not.
Sounds like they're in step with American opinion.
Right now.
okay.
And I'm encouraging them to remain in step. That was the nature of my commentary.
All right, so I'm going to just wrap up with a few points because I would love to hear questions, actually. So first, I do think we need to think about what is our goal. So Professor Bernstein suggested that we should be moving toward a colorblind society. We live in a very racialized society, and the question is, is colorblind the goal? The court certainly talks about that. However, our history of our nation is one that is very racialized. And so the question is, can we build a society that embraces difference and celebrates difference and recognizes that these differences actually enrich our democracy, or are we going to try to engage in erasure of that history? And why I disagree with the colorblind approach is because the history that we have of a racialized society is still doing a lot of work. It's still affecting opportunities. I explained that at the K-12 level. And I'll give you just another statistic. If you look at data from EdBuild that looks at funding for school districts that are 75% or more Black and Hispanic and 75% or more white, they're educating the same number of students, but there's a $23 billion gap between those districts. The funding gap is overwhelming. And so this idea that we can move to colorblind when we have not addressed the systemic racism that is affecting people's opportunity, I think is a foolish endeavor. We must embrace that. Second, I think that the goal of sort of dismantling DEI programs is going to be unsuccessful. And I'm going to tell you why. It's because we have a generation of young people, not only who are going to be more diverse, but who have grown up seeing instances like George Floyd, where it was clear that race was at work, and racism, which my co-panelist said is a meaningless word. I disagree. Racism is doing a lot of work still in our society, and this young generation has grown up seeing that race is still at work. So I can tell you when I first started teaching, I spent many weeks helping students understand race and racism still influences our systems in society. Now, the students come in saying, we understand that race and racism is doing a lot of work. What should we do about it? What should we do to dismantle that and truly embrace equal educational opportunity? And so we have a generation of young people who are aware of the impacts of racism and who are seeking to address that. And colorblindness will not do that. Second, I just want to agree with Professor Hawkins that admissions is not just about high grades and test scores. It is a much broader endeavor than that. And so this idea that we can see discrimination if we just compare test scores and grades is not how university admissions work. And so that's just not an accurate comparison. And then finally, this idea of, sort of who is qualified is really about who can contribute to the mission of each of these universities. And as we seek to build a pathway for leaders who are diverse, who are going to lead our nation that is increasingly diverse, the pathway to elite colleges is one that needs to remain open so that we have this broad debate and cross-section of individuals who can help to lead us in this more pluralistic reality.
All right. My comments, I think, again, I have a couple of different points. I'll try to keep these sort of empirical as opposed to personally moral for me, because I think we all have an opinion on the topic. But I mean, I guess the first one would be, I do think that affirmative action or diversity forward programs, whatever term we want to use, in some sense are going to be fairly hard to prevent. I mean, it was noted by myself as well as another panelist that, for example, you could simply weight students' experiences with kind of tribulation in life with a focus on racism, as opposed to simply looking at the race of individual students. And I think that's what every college I've been in contact with in my region is very likely going to begin to do. But with that said, all of this is, and another comment that was made that is obviously valid to some extent, is that most people who are admitted to selective universities don't sort of just get in. Now, I personally view this as a serious problem, actually. But I mean, almost every top 100 university has a system of legacy admissions. There are a number of other preferences. I forget the initialism for this, but preferences for the children of faculty members, coaches, members of the administrative staff, athletes. We sometimes forget this, and I think men in particular have a tendency to sort of excuse this one. But I mean, I'm a Big Ten alum. That's 15% of the student body at every one of those institutions. So I mean, all those points can be made. However, those points don't have the same sort of 14th Amendment implications that AA or diversity forward programs do. And I do think, moving to point two, it's a lot more challenging to justify those today. Again, Latinos, Hispanic Americans who have little or no significant history in most cases of bigotry in the past in the USA are a far larger group than African Americans. By the way, that has a lot of implications which we rarely consider. Hispanics are 18% of the population, Asian Americans about 7%. African Americans are on track to be the third largest minority group in the USA, not the largest. What are we going to do about that, if anything at all? It's worth considering. But the group most hurt by modern diversity forward admissions is Asian Americans. Again, that 1230 to 1100 gap with whites on the major board test just can't be ignored. Even as read diversity, there are 27 major Asian American populations. Now, one thing that I will say, kind of moving to my core area of statistics, when it's claimed that there's no proven discrimination against Asian American applicants, that's technically true in the sense that it's difficult to prove anything against good opposing counsel. But I mean, if you look, the term that would be used here statistically is P equals 0.00001. I mean, if you look at the admissions matrices for Asian American students, the admissions matrices for Black American students, and then the number of people admitted, there's less than a 1% chance, let's say, of that happening by blind chance. The implication that all Black students just happen to be nicer gentlemen than all Asian students is not only troubling, it just sort of empirically seems unlikely. And those were the kind of claims that were made by Harvard, correct? I mean, they had a personality review panel. I mean, this all seems very reminiscent of the kind of thing that was done to Jews and blacks in the 40s. I mean, they were sitting people down, having 1-hour interviews with them, and all of the Asian kids, and incidentally, most of the poor white kids just ended up being ranked as not very nice or very outgoing. I doubt that there is a empirical, methodological reason that's the case. I think that was the tool that was used, I will say, to shape student body diversity. Now, again, can you get around that kind of thing? I don't know. But again, on the size of the gaps here, I don't necessarily think school funding has much to do with this. Last on this point, Asian American kids from families that make less than $20,000 per year outperform African American kids from families that make $200,000 a year. And by the way, this is less often said on the right, outperform white kids from families that make $90,000 to $100,000 a year. So the idea that this is somehow due to how people differentially experience white supremacy, a friend of mine recently argued this with me in a very friendly debate, lovely person. But I don't think that is practically sustainable. I think if you study 3 times as much as the other 2 groups, you'll do better on tests. In the kind of complex thought pattern we're known for in the social sciences. But okay, a final take here, I think we'll really see what happens in the diversity forward sector. I know, personally speaking, that the right is going to attack this entire arena of programs. Christopher Rufo, sort of conservative gladiator, has gone on social media and said the next target is DEI. We're coming for the entire sector. I mean, probably well into the 7 figures has been raised. The question is, will there be an effective response to that from the universities? And again, this is an empirical, not a moral question. I think one thing that might be done is sort of offering more people disadvantaged status. We're now seeing this in the context of Jewish Americans. Does DEI apply to Jewish Americans or to quote-unquote MENA, Arab American individuals? I mean, you could attempt to break up the Asian group on the campus So that, for example, Filipinos, Vietnamese individuals, Hmong immigrants are one of the poorer, more troubled groups in the country for a variety of reasons, but they could be offered preferential status, preferred status, while Chinese and Indian Americans could continue to be disadvantaged. Can you split, can you divide and conquer? It's an interesting question. I'll close by saying this. A number of panelists, including Dr. Robinson, perhaps most eloquently, have noted that we live in a racialized society. The real question is that good or bad, and what can we do about it? My personal opinion is that ranking every one of the 172 census groups on some kind of scale of privilege at every one of the top 500 colleges in the country is probably not what's going to move us past race. And I don't mean that to be glib at all, but when the comment is made that college admissions is about a lot more than grades and test scores, I'll close with what an Asian American buddy of mine actually said when I brought that up. Why? Is there evidence that diversity has enough of a value, that the diversity outside the Asian category is so much more beneficial than the diversity inside it, that we should allow the 150-point test score advantages we currently do? I don't personally think so, but we'll see how society decides. Thank you.
So I'm not a social scientist, but as I said, I'm working on a special issue that involves a contribution by a number of social scientists, and I encourage you, when that issue comes out, to read their work, because they do have empirically grounded and sociologically documented evidence of the reasons why there are these differences, and I won't bother to dispute that point. But I do think that the real cruel irony, and this is another point that I have been made more aware of, although it was always kind of an observation, but more aware of doing this special issue in which one of the contributing authors has observed and written poignantly about the fact that the cruel irony of SFFA using Asian American applicants as the face of the attack on race-conscious programs is that the only evidence that was introduced in the Harvard case about disadvantages suffered by Asian American applicants in the admissions process comes from things like the alumni interviews that Professor Riley just described, that are not part of the race-conscious admissions plans that were disallowed. And they were the only thing disallowed in the SFFA case. So that means that the remedy that was both sought and achieved by SFFA on behalf of Asian Americans has no prospect of redressing whatever harms they're currently suffering. And that is a very cruel irony for an ostensible case taken and litigated all the way up to the Supreme Court on behalf of Asian American students who are going to enjoy no benefits of the decision that was issued by the court. But the final thing that I will say, as much as I disagree with Chief Justice Roberts' race jurisprudence across, a range of cases and domains, I think that, the one thing that I am encouraged by in his kind of final acknowledgement in the SFFA case is that he seems to have at least finally gotten to the point where Justice Kennedy was in the Parents Involved in Community Schools case in 2007 when he said, and again I quote, "The enduring hope is that race should not matter. The reality is that too often it does, and we simply cannot ignore that reality as much as we might want to." And I think that that acknowledgement is really important on behalf of someone who has had very problematic race jurisprudence. At the very least, he acknowledges that we can't get away from this.
Professor Bernstein, I know we're kind of up against the clock, but I do want to make sure we get the two questions in, so I was wondering if you, since you were a good friend of mine, if we could let the questioners maybe ask the questions first, and then,
I'll give you a 15-second thing, okay? Which is, I was not arguing for colorblindness as such, but against racial classification by the government that would permanently cement current racial division.
Thank you. I'll start here.
Thank you. Thank you so much. My name is Dr. Myrtle Alexander. I'm not a lawyer, but I am an economist, and the economics of education is my forte. So I've heard a lot of arguments here, and there are some considerations that I'd like to present to see if these were actually, right. Thank you. So if these things were taken into consideration, as we look at the founding of this nation, it was founded by, I heard mention of WASPs, and now we arrive at ADOS. But was there any consideration given to the 1893 Harvard resolution for the Committee of 10, where the increase in academics took place and the decrease of apprenticeships took place? That was, I believe, 30 years after the freedom of slaves, or the emancipation and so forth. And then we look at the Great Divide today, and we look at the 34 plus years of S40 and HR 40, which is the Reparation Act, just being researched. So it's almost like you gave freedom to your slaves, but you cut off their legs in the process. And I think that's where we've arrived at today when we look at things like affirmative action, and we look at the school system today, which is, in America, it's quite atrocious in public schools. And I'm here because I wanted to elevate schools, beginning in DC, and it's horrid. So one has to almost like run for Congress, but that's a whole different thing. So how do we address those, and how far do you go back to the root and to find out where did it all commence and when will it end, frankly? Thank you.
Given the time. Sorry.
Go ahead.
I wasn't sure if there was actually a question there. So I wanted to go back to the record, Professor Hawkins. You raised this several times about the personality scores. It's actually called the personal scores, which, by the way, were not exclusively judged by alumni interviews. It's a major part of the overall admissions process, all right? 30% of both whites and Hispanics, 30% got around the top 2 scores among the most qualified students. 45% of Black applicants got a top 2 personality score, and 20% of Asians got this high personality score. 20% getting called, the most likable, the nicest, with the best leadership skills, right? 45 for Black, 30 for white and Hispanic, 20 for Asians. And you're saying now that there wasn't evidence of systemic racism against Asians by Harvard. I have 3 half-Asian children. I cried when I saw this number. That's appalling racism. You talk about experience of racism by racialized people. Harvard was racially discriminating against Asians in this case at absolutely astonishing levels, saying, you're not nice, you don't have leadership skills, you're not kind compared to, yes, the white, Hispanic, and the African-American applicants. I just don't understand what remedy you would have seen come out of this case, given that. And I heard what you just said about this not resolving their issue. I'm wondering what you think should have been done.
So a couple of clarifying points. I think what you're referring to is the personal index, which is not a personality index. It's a personal index, and it's comprised of a number of different factors, one of which is counselor recommendation letters, and another of which is alumni interviews. It is, to my understanding and based on the factual record, not the case that Harvard admissions officers interview students and make assessments of student personalities. That information, to the extent that it is included in the personal index, comes from college admissions counselors' letters of recommendation and alumni interviews. So that is the reason why the trial court said none, to the extent that there is any implicit bias or some sort of discrimination against Asian Americans in either these recommendation letters or these interview assessments, they are not attributable to Harvard. Harvard is not doing that work. But again, I commend you to this article that's going to come out in the Journal of College and University Law. The social scientists, they go through the data. One of the, for instance, data points that they rely on, and this goes back to what Professor Robinson was saying about the kind of distribution of groups by race and ethnicity across kind of K through 12 educational context. Asian Americans are more likely to go to kind of larger, less well-resourced schools, and so therefore they go to schools with admissions counselors that may not be able to give them more personalized, kind of glowing recommendations like some of the white students. And so again, there is data to explain these things on bases other than racial discrimination by Harvard against Asian American students. And so That is the reason why the trial court concluded there is nothing that Harvard is doing in its admissions process that can be considered discrimination against Asian Americans. And the reason why I think that the remedy was inappropriate is because to the extent that it was college admissions counselors and alumni interviews or legacy admissions, athletic admissions, and admissions for donors and the children of faculty and staff, the prohibition on considering race is not going to address any of those, right? So Harvard is going to have to eliminate legacy, athletic, donor, and students of faculty preferences. Harvard is going to have to eliminate or in some way more effectively manage alumni interviews, right? And so those are the things that are not touched by the Supreme Court opinion that the evidence shows contributed to whatever disadvantage Asian American students might have suffered. And in fact, and again, the social scientists talk about this, the consideration of race operated to the advantage of many Asian American applicants, right? So not only are you not addressing the thing that the record evidence says contributes to Asian American disadvantage, the thing that contributes to many of their advantage has been eliminated. And so there is a complete mismatch between the interest of Asian American students in this case and the outcome that was wrought and that was sought, by the way, by SFFA.
Okay, if I could say something, I wanted to respond to, I'm not an educational economist or educational expert, but I think one really subtle scandal about this whole thing, whatever you think of affirmative action, is that you have universities like Columbia in New York, Brown in Providence, Harvard in Cambridge, Georgetown in DC, Johns Hopkins in Baltimore, Duke in Durham, and so forth, who have been extremely well-positioned and well-resourced to try to experiment, start their own schools, after-school programs, summer programs, whatever, to increase the pool and also figure out how, given the resource constraints that exist, since they can't do anything about it, we could get a larger pool of applicants from Hispanic and African American and other groups that are not doing as well educationally. And they, as far as I can tell, have basically done nothing. Across the board, invested zero, and it makes you wonder about whether the commitment to diversity is more of an aesthetic commitment as opposed to actually trying to improve educational outcomes and, if you will, enhance social justice.
So I'll just jump in because actually I am an education expert, and I agree with you, one, that we have a very broken K-12 education system. I often find that people from other countries come and say, why did you create something so deeply flawed from its initiation? So, but I think what's important to understand is that I do think that this, it's wonderful to end on a point of agreement. I do think that this opinion will cause universities to start to invest more in the pipeline for K-12. That will not be enough to fix a deeply broken system. One of the other things that's deeply broken is that the research definitely shows that students living in poverty need additional resources to compete on a level playing field. And more than half of our states either give less or the same resources to students living in poverty. We are an outlier across the world on this issue. Other countries who are eating our lunch on international test scores are helping students in poverty do well in school, and they are over-investing in them so those students can also succeed and contribute to those countries' economies and democracies. And so one of the things that we really need to fix in K-12 education is this regressive funding, giving more to wealthy families. We have to we all benefit when we invest more in low-income communities because those students then contribute to our economy and our democracy. So this is certainly something that, that is hurting us across all races and that we could, really fix if we chose to address it.
Can I just add one thing? I too am very happy to end on a moment of agreement, and that is the K through 12 area. And I also agree that there are countries in the world that have far fewer resources than we have that manage to do better at K through 12 than we do. I think an issue that needs to be thought about, again, when we're talking about funding, it's not, funding is not the be-all and end-all here. And the funding is U-shaped. Low-income schools tend to get a lot of funding. However, they have to use it on things that other schools don't have to use it on. They've got security issues that schools in very wealthy suburbs don't have to worry about. And I think we need to also focus on issues of school discipline, making sure that students get to school. We shouldn't be as tolerant as we are of chronic absenteeism. Vice President Harris actually worked on this issue when she was Attorney General in California, and I thought did a good job. And she got blown away by people on the progressive left who said you shouldn't be focused on absenteeism in this way. I mean, you shouldn't be so hard on these parents for not getting their kids to school. Get your kids to school. Get your kids to school.
Thank you, everyone on the panel. I'm sure there will be many interesting more articles written and symposia. I look forward to Professor Hawkins's. I've got a piece coming out in the SMU Law Review as well soon, so look forward to the continued discussion. Thank you, everyone.